why is this trial even continuing? Because I'm watching as all of the prosecution witnesses seem to be making Kyle Rittenhouse's case really well, that this was a self-defense case. And just off the top of my head, I think of things like the revelation that Joseph Rosenbaum said, if I catch you alone, to Rittenhouse, I'm going to kill you. Also, the revelation that Rosenbaum was diving for the barrel of the weapon. The revelation that Grosskreutz, the guy who had his bicep blown up by Rittenhouse, acknowledged, yes, in court, he was pointing his own gun at Rittenhouse before Rittenhouse ever fired. It seems like with all of this testimony, I'm beginning to wonder why this case was even brought.
Yeah, I mean, that's a very good question. I think in the absence of any social media pressure, this case would have been declined. Like prosecutors wouldn't bring it. And that happens every single day across the country. Prosecutors decline cases every day, even if they don't think very much of the defendant, they just decline cases they don't think they can prove beyond a reasonable doubt. I think that the amount of media attention put on this case made that decision not possible, especially with, I think, probably some political pressure from the mayor and other people in Kenosha, made it so they had to find prosecutors to bring a case that just wasn't even remotely viable. That said, who knows if the actual legal viability of the case is going to matter to the jury, but based on what's happened, it's been, I mean, outright embarrassing for the prosecutors. Their own witnesses have humiliated them. They found themselves constantly trying to impeach their own witnesses. All this stuff is bizarre. It almost never happens in criminal trials, to my understanding, that I've seen. And it shows how strange this prosecution is.
So is there any chance? I know that Dominic Black is also facing charges for giving a gun to a minor. What do you think of that case? And do you think that case has legs? The fact that he actually provided the weapon to Kyle Rittenhouse and perhaps put him in the position that he shouldn't have been in at 17?
So there's an interesting first question about whether or not Kyle was legally able to possess the AR-15 at age 17, right? And that's not as clear as people seem to think. Like a lot of people on the left seem to think that's open and shut, but the law as written in Wisconsin is very, very strangely written. It basically says that, minors aren't allowed to possess certain weapons if it's dangerous, et cetera. But then there's this caveat which says, and if they are not in compliance with these other statutes that deal with hunting and that apply to kids under 16. And so, for basically the way I did this analysis, I think almost a year ago on Periscope and on Twitter. But basically my reading of the statute suggests that under the way the proper reading of the Wisconsin statute, somebody who's between the ages of 16 and 18 is allowed to open carry a long rifle, right? Not a handgun, but a long rifle in Wisconsin. But that said, the judge in this case has kind of deferred. He thinks it's a question for the jury. So it looks like there's some good chance of a conviction right now on that misdemeanor gun charge, I think. But I think that charge is very vulnerable on appeal because it really is a question of what the law actually says. And that's the classic thing that, can be appealed and an appellate court can review it very carefully and come to a conclusion whether that gun charge can even stand.
Now, I should note that as we're speaking to Will right now, as this recording is happening, it's in the midst of Kyle Rittenhouse's testimony. Rittenhouse himself has taken the stand. He's first being questioned by the defense, who has called him as a witness. But just before we started recording, we got to see a limited amount of that. A lot of it just consisted of who are you, who did you go to Kenosha with, and what brought you there, and what activities were you doing that day. But is this wise, Will Chamberlain, to bring the defendant, in this case, Kyle Rittenhouse, to the stand in this trial? Is there wisdom here?
I don't think so. I think it's ultimately a bad decision. I can see some of the underlying logic, but I still think that the risks outweigh any potential benefits. So, in terms of the substantive benefit of testifying, like what new information that Rittenhouse could bring, he could speak to his own intent and what he was thinking and what he was doing.
Right.
But by the same token, we've had every single prosecution witness explain that Rittenhouse didn't start shooting until people attacked him. And so in closing, that it wouldn't be hard to demonstrate that Kyle was using self-defense, that he was clearly facing a deadly threat. You don't have to take Kyle's word for it. You can take all the word of the prosecution witnesses who conceded that fact. And then there's always the risk of just letting a prosecutor demonize your client and make them look bad on cross-examination. Cross-examination is a very powerful tool. I mean, just an endless series of questions that now Kyle is obligated to answer truthfully. And they can be leading. They can be very, it can be very, very tough. So a skilled prosecutor can really take advantage of it. On the other side, I think, is the benefit of maybe humanizing Kyle to the jury. I think that might help, right? Like if as just to ensure that if some of the jurors are not thinking about this from a purely legal perspective, that they're like, okay, well, this is just really a 17-year-old kid, and
right.